Senate Republicans are doubling down on that extremely controversial provision of the big, beautiful bill that would make it extremely difficult for states and individuals to sue the federal government and would make it so much harder to stop a president's actions. So why is that such a big deal? Oh, we're about to get into it. But first, let me tell you what just happened. So late last week, the Senate Judiciary Committee released the text of its section of the big, beautiful bill. The controversial provision is just this one little paragraph, and it says, no federal court is allowed to issue a preliminary injunction or temporary restraining order specifically against the federal government unless there is a bond posted by the plaintiff who brought the case. And that bond would have to cover the costs and damage the federal government would suffer. It's worth noting that this Senate version is different than the version in the House. In the House version, it also included language that said a federal court could not use federal dollars to enforce a contempt order. That part is not included in the Senate version. But the part that remains is still significant. Why? Well, you know, when a state or individual sues the federal government in court, that lawsuit is usually over a policy issue, right? So, for example, lots of red states sued the Biden administration over lots of things. But let's take something they were very successful in. They successfully sued the Biden administration over then President Biden's student loan forgiveness policy. When the federal judges in the conservative federal districts heard those cases, they almost immediately issued preliminary injunctions or temporary restraining orders that blocked President Biden and his entire administration from moving forward with student loan forgiveness as the case played out. Well, those red states did not have to put up a bond to bring that case, and that's because in federal court, judges traditionally don't collect a bond in a case against the U.S. government. Well, this provision in the Senate version of the big, beautiful bill changes that. And here's how. Let's take that same scenario with President Biden and his student loan forgiveness policy. If this was the law at that time, those red states would have had to first put up a bond. Money. How much money? Well, according to the bill, enough to cover the cost and damages the federal government would suffer by not being able to move forward with the president's plans. Now, depending on the case, that could be a few $1,000s, or that could be millions or billions of dollars. And if the states couldn't afford to put up that bond, the judge could not issue a preliminary injunction or a temporary restraining order to stop the Biden administration from forgiving student loans, even if the judge was pretty sure in the end he or she would rule that action is illegal. Does that make sense? Now, think about what would happen if the plaintiff wasn't a state. What if it was an individual challenging a new federal abortion policy? Or what if it was the National Rifle Association challenging a new federal gun restriction policy? Do you think those people would have $1 billion to put up for a bond? Probably not. Now, think about what would happen if this provision became the law, what it would mean for President Trump and his policies for the next 3.5 years. And don't forget, what goes around comes around. So you also need to be thinking about how this would work under the next Democrat who becomes president throughout his or her 4-year term. So you're probably thinking, why the hell is this happening? Where is it coming from? Well, as you know, multiple federal courts across the country have issued preliminary injunctions or temporary restraining orders blocking lots of President Trump's policies because those judges in those federal courts believe in the end they will rule that what he and his administration are doing is illegal. President Trump obviously does not like that. He does not like the fact that all these federal judges have stopped him from moving forward with lots of his policies. In fact, as I told you in this video, he has had so many of these preliminary injunctions and restraining orders blocking his plans that he filed an emergency appeal to the United States Supreme Court to ask them to try and tamp down on these federal judges and all of these orders nationwide. Well, by putting this one little paragraph in the big, beautiful bill, House and Senate Republicans are giving President Trump what he wants, regardless of how the Supreme Court rules in that emergency case. This provision, if passed, would make it extremely difficult for anyone, even a state, to put up the bond and stop a president, even if what he or she is doing is illegal. Now, there are some House Republicans who have admitted that they did not know this provision was in the big beautiful bill when they voted yes on it, and now they oppose it. Plus, there is this sort of wonky rule in the Senate, which I told you all about in this video, called the Byrd Rule, that may force this particular provision to be stripped from the Senate version of the big beautiful bill. But the fact is this: by keeping this one little paragraph in the big beautiful bill, Senate Republican leadership is doubling down, and they are going all in on this. So, if you have an opinion about this provision, either way, now is the time to contact your senator and make sure that your voice is heard. And if you want to read this little paragraph for yourself, I will email it out to you in my next Facts HQ email, so make sure you sign yourself up.